Sounds good. All right, you are Larry Fitzgerald Williams. And Mr. Williams, in cause number 25 DCCR 0985, is charged with capital murder. And Mr. Cashin has filed a motion asking that I reduce bond. We were here either last week or the week before. I've reset this case today to give everybody some time to get prepared on that motion. And Mr. Cashin, do you intend to call your client?
No.
Okay, you may call your first.
Okay, so what? Your Honor, no, sir. See. And what of this point?
Absolutely. I don't typically recall any. Jefferson County's not. Yes, sir. Absolutely. We don't need specific addresses. Or very rarely. Some officially would. Sanderson. And Mr. Williams, if you'll just kind of step around closer to Mr. Cashin, kind of right there, you're good right there, sir. And maybe you can come right up here in the front, please. Good morning. Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You may proceed.
I want to live in and you never get on TV. And
ma'am, can you speak up so that I need to hear you in the court reporter needs to hear you as well, please? Thank you.
what is it? She young, you are. Does he tell you God you Beaumont? Yes. What here in Beaumont? Now on the owner. So, Fitzgerald Williams, prior to him being was either. And also become and yeah. Ever, you know,
Here's what the defense is doing, and it's textbook. They're not arguing innocence. They're arguing reliability, job history, family ties, money for collateral. The goal is simple. Convince the judge this man will show up to court if released. Because at a bond hearing, flight risk matters just as much as the charge itself.
You know what a bond should be. And you have to go to a bond. And the bond was should work. And when she has to buy stock, you want to make and the $2 million bond helps with that. Also, the other bond is strong. Right? And what you want.
Let's pause on that number, $10 million. Bonds aren't supposed to be punishment, but when a bond is set this high, it becomes effectively unreachable. In legal terms, this is what defense attorneys call a no-bond bond. And the entire hearing is about whether that number is justice or excess.
And, yes, price bond like $50,000. Yeah, travel, winning, property, money, or sure law. You do that, so you have understand, you go sign. in the text of my go along with the law.
I'm sorry, I can't hear you.
So,
I still didn't understand what you said at the end. Oh, he's in good standing.
have you ever known Larry after feeling for it? And he is on the other part of the piece, and I said, okay, so should he ever fail to acknowledge come to court? He always came to court every time on having problems with him showing court. And
All right, thank you, Mr. Cashin. Mr. Smith, any questions of this witness? Thank you, ma'am. You can go back down and seat. Any other witnesses, Mr. Cashin?
no, ma'am, but Your Honor, I would like to point out that the family member to the courtroom.
Yes, sir.
Tanisha Williams' daughter, who was counseling in the courtroom, she would say the same thing. And it's actually just about his daughter, the Alicia Clay, she was also a girl. She was in the same thing.
Thank you.
Presently his blind, which I just
Mr. Williams, you can sit back around.
presently his blind, was most steps in the down. Where the greatest steps and the opportunity is. And Mr. Williams, although he has issues in court, issues, he was never here. And see, fire, kidney court, fire, kidney involved with court business, shows he is not ready to leave that way. Why did he come to court? Because the other court requires monitor, maintain location like GPS. Doesn't work, so they like this is counsel, making sure monitor 30 hours for the close to be outside. Even if the boss still got to be out.
Now we hit the collision point. The defense says he always comes to court. The state says he ran. Same facts, radically different interpretations. This is where bond hearings are won or lost. Not on proof beyond a reasonable doubt, but on which story feels more believable to the judge.
Okay. Mr. Smith?
The state responds to the capital murder, based on the fact that he had come back for trial, the murder of the victim, who was also the victim of aggravated assault. Very shortly before that was actually going to be called for trial. But fled past the evening with Marvin Fuji, who was to be located, shows that he is likely to run. Yes. Give him all. Family of is also refused to realize that he is not. Yet, during the two trial, she was expecting Your Honor, the judge said Williamson was located the time I'm trying to play to my that he was in Crown. Yeah, he's coming to so he had heard of his report down here about the leg murder, so coming to talk. He's one a process, but he's a process. So, but like, so I said, into the chat, he was arrested in D.C. Was.
All right, so,
This is a risky counter by the defense. Saying he went to Houston to consult a lawyer might sound reasonable, but judges hear that claim a lot. And without hard proof, it often sounds less like preparation and more like damage control.
Obviously, this case is date of this case precedes any modifications that happened in our legislation cycle that has come into law as of yesterday. One of those is actually that it is appropriate, and if someone is out on bond for a felony offense, and the allegations are that they commit another felony offense, to have no bond, which is something that is more strict instead of more lenient with regard to bonds. I believe the fact that Mr. Williams has come to court when required obviously is nice and great, but the fact that the allegations are that, and it's their allegations, he has been found guilty, but I am entitled to take into consideration the underlying facts of the case. And so based on the offense that he was charged with initially, the aggravated assault, based on the fact, this new allegation is that the victim or the complaining witness in that case is now the victim in this alleged case, I do not find that it would be in the best interest of our community to grant the motion, and I am going to deny that motion to...
This is the legal bottom line. The judge isn't declaring guilt, but she is allowed to weigh the allegations, the timing, and the risk to the community. When the alleged victim in one case becomes the victim in another, that changes everything. And in this courtroom, public safety outweighs the presumption of release.